Introduction. Disclosure as a legal trigger point. As we move into Chapter 4, we shift from understanding agency duties to documenting them properly. In Arizona, agency is not just created, it must be disclosed. This is one of the most critical compliance areas for real estate professionals, and it is heavily enforced by the Arizona Department of Real Estate, ADRE. The moment you begin discussing a real estate transaction with a prospective client, your disclosure obligations begin. Under ACR 4-28-1101, licensees are required to clearly disclose who they represent and how they represent them. Failure to properly disclose agency relationships is one of the most common violations seen by ADRE and can lead to disciplinary action under ARS Section 32 to 2153. The purpose of agency disclosure exists to eliminate confusion. In commercial real estate, where transactions often involve multiple parties, brokers, and advisors, it is easy for roles to become unclear. Disclosure ensures that all parties understand who represents whom and what duties are owed. Without clear disclosure, clients may assume representation where none exists, leading to misunderstandings and potential legal claims. The goal is transparency, making sure that every party knows exactly where the agent stands before any confidential information is exchanged or negotiations begin. The Real Estate Agency Disclosure and Election READE form the primary tool for agency disclosure in Arizona is the Real Estate Agency Disclosure and Election READE form. This document outlines the different types of representation available and allows the client to acknowledge and consent to the chosen relationship. The READE form must be presented at the earliest practical opportunity, typically at the first substantive contact. In commercial real estate, this could occur during an initial meeting, property tour, or consultation. The form is not just a piece of paperwork, it is a legal document that protects both the agent and the client by clearly defining the relationship. Timing requirements. When disclosure must occur, timing is everything when it comes to agency disclosure. Disclosure must occur before the agent provides any advice, shares confidential information, or begins negotiating on behalf of a client. Waiting too long can create implied agency, where the client believes they are being represented even though no formal agreement exists. This is a major risk area. In commercial real estate, where discussions often involve detailed financial analysis and strategic planning, it is especially important to establish agency early. Proper timing ensures compliance and helps prevent misunderstandings that could lead to disputes. Types of representation disclosed on the READE. The READE form outlines several types of agency relationships, including seller/landlord representation, buyer/tenant representation, and limited representation. Each option carries different duties and limitations, and it is the agent's responsibility to explain these clearly to the client. In commercial real estate, clients may have prior experience or specific expectations, making it even more important to ensure they fully understand their options. The agent must not simply present the form, they must educate the client on what each choice means and how it will impact the transaction. Common mistakes and compliance violations. One of the most common mistakes agents make is treating the READE form as a formality rather than a critical compliance requirement. Failing to present the form at the correct time, failing to explain it properly, or failing to retain it in the transaction file are all violations that can lead to disciplinary action. Another common issue is incomplete or inaccurate forms. In commercial real estate, where transactions can involve multiple properties and parties, attention to detail is essential. Agents must ensure that the form is fully completed, signed, and properly documented. Broker supervision and record-keeping requirements. Agency disclosure is not just the responsibility of the individual agent, it is a brokerage-level requirement. Under ACR 4-28-1103, designated brokers must supervise agents and ensure that all required disclosures are properly executed and maintained. Additionally, under ARS Section 32 to 2151.01, brokers are required to retain transaction records, including agency disclosure forms, for a specified period. Proper record keeping is essential for compliance and provides protection in the event of an audit or complaint. Real-world application. Commercial scenario. Consider a scenario where an agent meets with a business owner looking to lease retail space. During the conversation, the agent begins advising the client on market conditions, rental rates, and negotiation strategies, but fails to present the READE form. The client assumes the agent represents them, but no formal disclosure has been made. Later, a dispute arises regarding representation and compensation. This situation could have been avoided by presenting the READE form at the initial meeting, clearly establishing the relationship from the start. Bringing it all together, disclosure as the first line of defense agency disclosure is the first step in every real estate transaction and one of the most important tools for risk management. It sets the tone for the relationship, clarifies expectations, and ensures compliance with Arizona law. In commercial real estate, where transactions are complex and stakes are high, proper disclosure is essential. By understanding and consistently applying disclosure requirements, agents can protect themselves, their clients, and their brokerage. As we move into the next section, we will explore how these disclosures translate into written agreements and contractual obligations. Online discussion. Why must the READE form be presented at the earliest practical opportunity? Answer. To ensure the client understands the agency relationship before receiving advice or sharing confidential information. What risk arises when agency disclosure is delayed? Answer. Implied agency, where a client believes they are represented without a formal agreement. Why is proper documentation of the READE form important? Answer. It ensures compliance with Arizona law and provides protection in the event of disputes or audits. True or false questions. Agency disclosure is optional if the client seems experienced. Answer. False. The READE form must be presented before negotiations begin. Answer. True. Implied agency can occur if disclosure is not made early. Answer. True. Brokerages are not responsible for ensuring disclosure compliance. Answer. False.